Good morning, everyone. आज आपण थर्ड युनिट बघणार आहेत. फर्स्ट स्टेक होल्डरचं झालेलं आहे, रोल ऑफ स्टेक होल्डर. सेकंड प्रोफेशनल इथिक्स. थर्ड युनिट जनरल प्रिन्सिपल ऑफ कॉन्ट्रॅक्ट मॅनेजमेंट. ओके, मेन व्हॉट इज मीन बाय कॉन्ट्रॅक्ट मीन्स कॉन्ट्रॅक्ट मॅनेजमेंट. कोणाला सांगू शकताय? तुमचं एस्टिमेटिंग कॉन्ट्रॅक्ट मॅनेजमेंट कॉन्ट्रॅक्टचा सब्जेक्ट झालेला आहे आपल्याला. थर्ड युनिट टेंडर कॉन्ट्रॅक्ट प्रोसेस. तेवढंच आहे थर्ड युनिट मध्ये. General principles of contract means agreement enforceable under law to do or abstain to do something in exchange for consideration. Okay, means contract is a managing software program. It's enable to user easy store and find contract information such as name, address. Okay, any enforce agreement. Slide पुढे जात नाही, एकच मिनिट. Slides look good. Okay. General principles of contract. What is contract management? Contract management are essential for contracts. This article address the meaning of contracts and essential elements that are fundamental to creation of valid contracts. Contracts are defined under the Indian Contracts Act 1872. जर point आहे ह्याच्यावर आपण बघूया पुढे. Which is referred throughout the articles for the purpose for seeking relevant provisions means applicable for determining the validity of the contract under law. Means contract management is the process of managing agreements means for their from their creation throughout to their execution by the chosen party and to the eventual termination of contract. Means key activity involve performance analysis against the contract terms means maximum operational financial performance and identify the financial reputational risk throughout non-competition contract terms. Okay. What is agreement and what is constituent an agreement? An agreement is a promise between two entities creating mutual obligation. Means section 2E for Indian Contracts Act 1872. The main general principle of contract management. 1872 defined as the agreement as every promise and every set of promises means forming consideration for each other in an agreement. This agreement constitutes several parties for the valid contracts. Means they are promise acceptance and consideration promises the competency and free consent. They are the agreement of contract management. Main contract management software is digital means stores all contracts into the central repository providing way for stakeholders, means such as a legal compliances department to search for review contracts, means eliminating the need to manually locate the ship, mean through stick paper manual. Means contract management is the software also the managing access to the contracts. So only the authorized people in an organization means can view any particular contract, improving security. Only the software provides alerts to the key contract. Means contract is expiry dates for the allowing business and means agreement avoiding them and being locked into the contract automatically, means ruling over from year to year, increasing unfavorable terms. Okay, the basic आहे रिलेशन कॉन्ट्रॅक्ट ह्याचं काही नाहीये. व्हॉट आर द डिफरंट टाइप ऑफ कॉन्ट्रॅक्ट ह्याचं इंडिव्हिज्युअल आहेत आपल्याला पीपीटीज मध्ये बघूया. This section talks about the different types of contract that are observed under law. And some of them are adhesion contract, allowance contract, unilateral contracts, express contract, implies contract, valid and ह्याच्यावर पॉइंट आहेत व्हॅलिड अँड वाइडेबल कॉन्ट्रॅक्ट. ओके, क्वेझी कॉन्ट्रॅक्ट्स आर द टाइप्स ऑफ द कॉन्ट्रॅक्ट्स. मेन पार्ट इंडियन लॉ 1872 आपण बघूया. ते जनरल बेसिक होतं, जनरल प्रिन्सिपल ऑफ कॉन्ट्रॅक्ट. हा, फर्स्ट थर्ड युनिट मधला फर्स्ट पॉइंट आहे इंडियन कॉन्ट्रॅक्ट ऍक्ट 1872. ओके, what is contract and agreement? Main contract according to section 2H means is the section contract चे account sections असतात agreement enforcement चे law चे. ओके, ते पण सांगते. agreement to the section H is the contract defined as the agreement enforceable by law. What is the definition of contract? Contract is an agreement enforceable by law. What is agreement? Agreement is the according to section 2E every promises promise and every set of promises forming consideration for each other. Means consideration is the return benefits the parties to the contract get. Means agreement is equal to offer plus acceptance. Means Indian Contract Act 1872 काय म्हणतो तर prescribable law relating to the contract in India. Means is any key act regulating Indian contracts law, and the act is based on the principle of English common law. Means it is applicable to the all state of the India. Means it determine the circumstance in which promises made by the parties to contract means shall be legally binding. Means under section 2H. Means 2H is the Indian Contract Act. Means define a contract as an agreement which is enforceable by law. Okay. Then agreement plus contract. Difference agreement and contract. Difference between offer, agreement is offer plus acceptance, contract is the agreement plus it is a legal enforceability. Means the agreement may be create social or legal obligations. Means creates contracts only legal obligations between the parties. Then agreement, all agreement do not become contracts, and contracts is the all contracts are based on agreement. Okay, this is the main difference between the agreement and contracts. Means according to two sections, section 2H, 2E, 2B, 2A, the main section for the acceptance in contract H. Okay, means any when person whom to the proposal is made, means significance his assist their offers is said to be accepted. Means proposal when accepted becomes a promise. Okay, then consequence and an idea. According to section 13, meeting of minds or identify of minds or receiving the same, means think in same sense at the same time. Okay, main elements of the contracts. First, means essential elements of valid contract, section 10. Okay, first valid offers and acceptance. Second, intention to create legal relationship. Third, consequences, IDM, means lawful consideration. Then capacity to contract, free constant. Then legal of objection, object, possibility of performance, and writing and registration. Okay. Main acceptance should means valid offer and acceptance is essential for valid contracts. Means acceptance should be absolute, the unqualified. Means if the parties are not concurrent all the matters concerning the offers and acceptance, when there is no valid contract. For example, capital means A section means say to be B, means if I offer to sell my car 50,000, means B replied I purchase is 45,000, means this is not acceptance. Means hence it is amount to the counter offers. Means it should be communicated to the offer. Means to conclude the contract between parties and acceptance must be communicated. Some prescription form means mere mental determination, means offer part of the offer and acceptance, means the offer does not amount to the valid acceptance. Okay. Then classification of contracts. Three classification. First is legal effects, performance, third formation. Legal effects मध्ये 5 types आहेत, performance मध्ये 4 आणि formation मध्ये 3. Okay. Legal effects. First, valid contract, void contract, voidable contract, unforceable contract आणि illegal contract. Performance मध्ये unilateral contract, bilateral contract, exclusive contract, executory contract. For formation, express contract, implies contract, and quasi contract. These are the types of the classification of contracts. Okay. Write down main 3 type of classification. जे जे important आहेत फक्त नाव तर लिहून घ्या. ओनली नाव पण लिहून घ्या, काय प्रॉब्लेम नाही. Legal effect, second performance, third formation. There are 5 types legal effects, then performance 4 types, and formation 3 types. Valid contracts means then valid contracts is an agreement enforceable by law. Means an agreement means valid become enforceable by law. Means when all essential of valid contract as laid in section 10 are fulfilled. Okay. सेक्शन काय असतात पुढे आहेत टाइप्स ऑफ कॉन्ट्रॅक्ट मध्ये सेक्शन ABCD, त्यामध्ये कुठले लॉ आणि अग्रीमेंट होतात ते आपण बघूया. Then second, void contracts means agreement which was legally enforceable when entered into but which has become valid due to supervening. Means supervening impossible of performance. For example, contracts between citizen of Pakistan and India is a valid contract. Means during peace, but it is was breaks out between 2 countries. Means the agreement will become valid contract. Void contracts. Okay. Means any means any contract which cases to enforceable by law means become void when it is cases to be enforceable. Okay. Then void contract, voidable contract, unforceable contract. What is unforceable contract? Unenforceable contract means unenforceable. It is a contract which is actually void, valid means cannot be enforced because of some technical defense such as not writing under stamp. Means such contracts can be enforced if the technical defense means in all is removed. And unforceable is the such means such as not in writing and and under stamped means enforced because the technical difference in contracts enforceable technical defect involved is removed. Okay, means for example oral agreement for arbitration is enforceable because the law required that arbitration agreement must be writing, means is oral agreement is the arbitration and reduce the writing, it will be become a enforceable. Okay, last illegal contract, sorry, third राहिलं voidable contract means according to the section 2 मध्ये first मध्ये मी बघितलं section 2G. Okay, section number voidable contracts मध्ये काय तर agreement which not enforceable means law either of parties is void, means no legal right or obligations can be arise out of the void agreement, means it is voidable into the that is from very inception, means for example agreement without consideration or with a minor. Last, illegal contracts means an illegal agreement is one the object of which means unlawful, means such as the agreement cannot be enforced by law, means the illegal agreement are always void, means into the, that is void from very beginning, means the contract commit means illegal contracts and cannot be enforced by the of the law. Okay, means agreement with the minor means void means but not illegal. Very wide agreement is not illegal, means unless object consideration impossible, means immoral opposite to the public policy, and void contracts does not affect the collateral contracts. Mean illegal agreement is like infection diseases, and it is fatal not only to maintain contract but collateral contract as well. Second, perform unilateral contract, bilateral contract, executory contract. Okay. Then third, formation, express contract, implies contract, and quasi contract. Okay. First, executed contract or executory. I need to explain. Executed contract is a contract where both the parties to the contract means have fulfilled their respective obligations under the contract. Executory means is the contract where both parties to contract means have still to perform their respective obligations. Okay. Then unilateral unilateral and bilateral. Unilateral is the uni means unilateral is the one which is a promise on one side, means is exchanged for act on their and act on other side. Means example, a worker does not manual labor means at request for Miss B section, means particular day on completion of work B means obligation to pay him wages because A is the already performs his obligations. Then bilateral contracts is the there, and these are the contracts means where promises on the one side and exchange for promise on their on the parties of other uh, other party. Okay, then formation, express contract. Express contract is the one which is made by the words means spoken or written. Express means it is the made words or spoken written. Then implied contract where the proposal or acceptance is made means otherwise the word in then in word means it is implies contract, means implied contract can be made out of the surrounding circumstance in the conduct of the parties and made them. Then last quasi contracts. Okay. It is a contract means is there no intention on either side to make contract, but the law imposes means impose contract, and in such contract right obligations means arise the not made by any agreement because the parties but the operation of law, means these finders of lawsuits lost and goods, and similarly where certain books are delivered to the wrong address in under an obligations either to pay for them and return them. These are the main three classification of contract. Okay. Then types of contracts and based the legal effects. First, valid contract, invalid contract. This is important आहे. Types of contracts पण separate PPTs आहेत ते पण दाखवेन मी. Valid, invalid, void, voidable into the and नंतर becomes void and voidable contract. Okay. Types of contract based legal effect. Valid contract means if all conditions are fulfilled to call it as valid contract. Then invalid contract, in a contract if any one condition is not fulfilled. Okay. Then is valid means voidable into means agreement which is not valid from the beginning. Becomes void means an agreement which is valid the beginning but due to some supervening impossibility the contract become void. Voidable contract means contract which is valid unless until avoided by either the parties. Okay. Main types of contract means validity means now contract is can identify the various types of contracts means proper type of contract essential as allow that decide the legal effect means the legal agreement where the many Indian contract at 1872 is the voidable contract and void voidable and void agreement means any void contracts is the essential of contract agreement is legally binding and enforceable. It must be qualified all the essential of the contracts. Okay. Then invalid वगैरे झालं. Okay. Illegally contract. Illegally means an agreement forbidden by the law means it involves the commission of crime or violate public policy or immoral in nature. Okay. Means any agreement that leads to one or all the parties breaking the law or not conforming to the norms of society demand means illegally by the court means contract opposed to public policy is also legal means several example may be cited to the illustrate means illegally contract for the example agrees to sell means narrow cities and also the contract has all the essential elements of valid contract is still legal means any legal contracts are deemed as void and not enforceable by law. Okay. Then unenforceable contract it is a void valid but due to some technical defects the contract become void. In case defects are removed the contract is enforceable means lack of registration lack of signature etc. Means any unenforceable means contracts are rendered means unenforceable by law due to some technical the contracts cannot be enforced means against any of two parties means for example agrees to sell B means sale number B is the 100 kg for rice and one 10,000 but there are the flood in the state all the rice crops means were destroyed means now this the contract is unenforceable means cannot be enforced against either the parties. Okay, these are the main types of the contract. Then based on performance express contract implies contract वर जे बघितलं तेच रिपीट आहे त्याच पॉइंट मध्ये डबल आहे express when contracts are either in writing or in oral. Then implied contract means when contracts are neither in writing nor in oral but enforced from the acts or circumstance of the parties case. Means quasi contracts it is not actually intended means into by parties and but some imported on the parties by the law. Okay. Then offer जे आहे तोच आहे टाइप्स क्लासिफिकेशन आणि त्यामध्ये सेक्शन कुठले सेक्शन 1 मध्ये कुठलं पार्ट आहे बी सी सेक्शन 2 मध्ये तेवढं लक्षात ठेवलं तर कॉन्ट्रॅक्ट्स अँड अग्रीमेंट अँड टेंडर मध्ये तेवढंच आहे. ओके. देन offer according to section 2A means when person signifies to another willingness to the to abstain means from doing sometimes with the view to obtaining this assist of that other to such as act or absence means he is a make a proposal means types of offers. First, express offer, implies offer, specific offer, general offer, cross offer, con- uh, contour offer, and standing offer. First, express offer means when offer is given to another person, means either in writing or in oral. Okay. Second, implies offer means when offer is given to another person, means neither in writing nor in oral. Third, specific offer when offer is given to specific person. Then general offer when offer is given to entire world at large means Kelly versus carbolic smoke bomb CO. This is the general offer means entire world in the large. Cross offer when both the persons are making identical offers to each other means ignorance of their of others offers. Then contour offer when person to whom the offer is made means instead of accepting the terms of that offer means desired or modification of the same. Then standing offer means an offer which remains continuously enforceable for a certain period of the time. Okay, these are the main types of the offer. Write down names of offers: express, imply, specific, general, cross, contour, and standing. पूर्ण थेरी पार्ट असल्यामुळं जनरली तुम्हाला बेसिक कॉन्ट्रॅक्ट रिलेटेड बघून घ्या. ह्याची सेपरेट एक बुक आहे कॉन्ट्रॅक्टचा जनरल प्रिन्सिपल ऑफ कॉन्ट्रॅक्ट मॅनेजमेंट, पण मी PDF शेअर करेन. सेकंड गोष्ट अजून एक सांगायचं विसरले, IAC IAC आहे 4, 5, 6 ला टाइम टेबल मी टाकेन सरांची साईन राहिल्यामुळं. ज्यांनी अब्सेंट आणि जे फेल आहेत त्यांनी प्लीज परत एकदा IAC द्यायचंय. नंतर 2 दिवसांनी IAC नंतर परत तुमचा जो आतापर्यंत प्रोजेक्ट वर्क कम्प्लीट झालेला आहे पूर्ण विथ एक्सपेरिमेंटल असेल, जे थेरी रिलेटेड असेल, सॉफ्टवेअर रिलेटेड असेल, जे वर्क आहे सेकंड फेजचा सेकंड प्रेझेंटेशन चालू होईल. कारण थर्ड प्रेझेंटेशन फायनल तुमचा ओरलच राहणार आहे. ओरल आहे त्याला 300-200 मार्क आहेत, तुम्हाला 300 मार्क आहेत. तो सगळ्यांनी प्रोजेक्टवर फोकस करून जितकं झालं आतापर्यंत कोणी काही केलं नसेल तर आता 2-3, 4-5 दिवसात करून ओरल आपलं IAC नंतर लगेच प्रेझेंटेशन असणार आहे. परत 15 तारखेच्या पुढे IAC 2 असणार आहे, कारण आपलं 5 जून टर्म एंड आहे. सो वेळ खूप कमी आहे. सगळ्यांनी प्रोजेक्ट फोकस करा, कारण फायनल इयर फक्त प्रोजेक्टला 300 मार्क्स आहे तुम्हाला. ज्याने वर्क केले नसेल चालू करा, ग्रुपला बोलवा, डेली काय असेल तुमचे ब्लॉक रिलेटेड, कॉन्क्रीट रिलेटेड असेल, बांबू रिलेटेड असेल, जे काय वर्क असेल कॉलेजमध्ये येऊन तुम्ही वर्क करा. सॉफ्टवेअर रिलेटेड असेल 5 जण असेल तर 3 जण वर्क केला, दोघी येऊ शकला नाही तर तुम्ही त्यांना प्रोजेक्ट लिहायला फॉर्मॅट आहे सेंड करायचं, ते करतील. तसं तुमच्यात कोऑर्डिनेशन करा आणि लवकरात लवकर, कारण आता IAC नोटीस आज आता टाकेन 1 तासात वगैरे 1 वाजेपर्यंत सरांची साईन झालं की नंतर उद्या परवा वगैरे प्रोजेक्टचे नोटीस वगैरे सेंड करेन. आता एकदम अचानक एवढं केलं की तुमचं आधीच MPSCचं एक्झाम असल्यामुळं तुम्हाला 30 तारखेपासून एवढं हे करणार. तो सगळ्यांनी तेवढं लक्षात ठेवा. ओके, देन Carlyle versus carbonic smoke ball means that is advertisement was not unilateral offer means चौथा पॉइंट आहे ह्याच्यात आपल्या ऑफर्स ह्याच्यामध्ये. ओके, हे जनरल ऑफर मध्ये difference means advertisement for not unilateral offer to all the world means but offer restricted to those who act upon to the terms content in the advertisement means the satisfying condition of using smoke ball means constant acceptance of offer means purchasing the using smoke ball means good consideration, more people buying any advertising was clear benefits to carpooling. Okay, त्याचं काय एवढं डिटेल मध्ये नाहीये. मेन आपल्याला लीगल अग्रीमेंटचे वगैरे बघायचे. हा हा लीगल रूल्स फॉर ऑफर. फर्स्ट, offer must be given with the intention to create legal relationship, and for versus in force means offer must be definite. Any tolerance, any there are different offers, invitation offers and invitation to sale. Okay, offer must be communication means communication of offer is completed only when it reaches the person to whom it is made. Okay. Mere statement of price is not an offer. The legal offer of the agreement. First means Harvey versus Pacey means first telegram or will not bomb. त्याचं काही नाहीये, त्याचं काही communication acceptance. Main rules, legal rules for offer and then acceptance. त्याचे ते part आहेत. Means offer acceptance. Okay, means offer its use rules means offer is usually understood proposal means according to section 2. Means contract act means individual is said to have made the offer means when implies to another his readiness to avoid doing anything with respect to getting the constant of that other such act is restrained. Okay, means legal, main legal offers आहे ते legal rules for offers. Acceptance can given whom to offer was made. Okay, unqualified has been absolute unqualified. Acceptance must be communicated, implies acceptance. Okay. Main according to section 2, and person made to proposal, another to whom proposal is made. If proposal is essential, there to call it as acceptance. Main definition of acceptance. What is acceptance? Is often means said to that accept is an offer. What is a light match is barrel means gold powder. For a successful contract means there must be valid offer followed by the offer being accept means later more essential for valid acceptance. Means main acceptance Indian Act 1872 means Indian Contract Act 1872 is the main acceptance to the section 2B. When the person to whom proposal has been made signifies the assist theorem means any offers is said to be accepted means the proposal when accepted become a promise means so define statement the offers to the whom proposal is made unconditionally accept their offer and it will amount to the accept means after such an offer is accepted offer become a promise. Say for example offer to be B means buy B car rupees means for lakh B means accept such as offer. Now this become a promise means when proposal is accepted become a proposal it is also become a irrelevant means an offer does not create a legal obligation but after the offer is accepted it become a promises means promises because the create legal obligations between the parties means any offer can be revoked before it is accepted but once acceptance communicated cannot be revoked for withdrawn. Okay, then legal rules for acceptance. Acceptance must be absolute and unconditional. Then acceptance must be given as per the mode prescribed by the offers. Then acceptance must be given before the lapse of time or within reasonable time. Then acceptance may be given by any person in case of general offer. Means acceptance must be absolute unconditional. Means any in the case means first acceptance must be absolute means in case of specific proposal means the offer it can only accepted by the person means it was made to no third person without the knowledge of the offers can be accept the offer means many means cap only the given means accept the only given by the whom the offers means any काय म्हणतात ते offer means when the proposal is general offer, then anyone with the knowledge of the offer can accept it. Okay. Then next, acceptance must be communicated. Means the any for proposal to become contract means acceptance of such proposal must be communicated. Means to promiser, the communication must happen in the any such forms, normal course of business in specific form of this. Then acceptance must be given by person to whom offer is made by the authorized person. Acceptance must be communicated. Mental acceptance is no accept or accept must be derived from silence. Acceptance must not be received to offer. These are the main types of means legal rules of the acceptance. Okay. Communication of offers and acceptance according to section 4 is the communication of offers is complete when it becomes to knowledge of the person whom it is made. Means the communication of acceptance is the for two types means and against the proposer means when it is put into the course of transmission to him means who has to be out of the power of the acceptor. Then and as against the acceptor when it become knowledge of the proposal. Then revocation of means revocation of offers and acceptance. The proposal may be revoked means at any time before the communication of acceptance is the complete as against the proposal, but not the afterwards. Means an acceptance may be revoked any time before the communication of acceptance is the complete against the acceptable, not the upward. Okay. Then communication of for 3rd June, communication of accept. The main date are the acceptance communication and against the proposal 5th June, against the acceptor 7th June, proposal can be revoked before 7th, acceptance revoked before 7th. There is a lapse of offer means revocation, lapse of the time, death of the incentives of offers, counters offers, acceptance not as per the prescribed mode. The main offer rejection of offer by the officer and description of subject matter of the contract. First B offer to sell his house to for example आहे ह्याचं काय हे नाही डिटेल मध्ये consideration. Okay, what is consideration? First काय offer बघितलो, acceptance, contract. Okay, fourth आहे consideration. According to section 2D, okay, consideration is defined as when the desire of the promiser or promises or any other person has done or absent from doing or does promises to do means abstain from the doing something such as act or absence or promises called a consideration for promises. Okay, means any party to agreement whom promises to the something must again means something in return. Something in return means any means return is called as consideration. Okay, illa पण legal rules आहेत consideration ला. Okay, write down definition consideration. Consideration in contract. Okay, legal rules for contract means consideration law आहे means including given enter into the contract and that is sufficient to render promises enforceable in the court. Okay. Then legal rules. Legal rules of rules has two consideration. The consideration must be always to provide at the desired of the promiser. Okay, means any law for consider legal rules of consideration. Means any consideration must always provide at desired of the promises. The part payment is not good consideration. Means consideration must move from the promises. Means but not flow to the promiser. Means it may be provided by the promise or any other person. It may be past, present, or future. It need not be adequate. Means it must be of some value in the eyes of law, and means it must be real, certain, and possible. Means it must not be illegally or opposed to public policy. Means consideration cannot be illusory. Means consideration must not be past. Okay. Main consideration concept is English law. Means a simple contract is not for specific a special contract. Means contracts mandate means concept has been adopted other common law justification. Okay. Then contract without consideration is valid expectation. Law and affection, compensation for voluntary service, promise to pay, time barred defect, completed gift, no consideration is necessary to create an agency, charity, and gratuity of contracts. Then structure to the contract means in general rule of contract law means that only parties to contract can sue and be means assured on that contract. This rule is known as the doctrine of privacy means privacy of contract एक point आहे त्यामध्ये पण हा point आहे that is relationship between parties to contract. Okay. Exceptions is the trust or charges means marriage settlement parties or other family arrangements such as any established is assignment of contracts and contract with agent and conventional running with land. थोडे डिटेल मध्ये नाहीये जे जे मेन आहे ते तुम्हाला सांगत आहे. मेन मायनर रूल्स कुठले लीगल रूल्स कुठल्या ह्याला तेवढं बघितलं तर चालतंय. Means according to Indian Majority Act Section 2(3), sorry, minor is defined as the person under age of 18 years. Okay, means it is following case if person is said to the minor means it does not complete the age of 21 years. Means any person under graduation and Words Act 1890 means any person who come under superintendence of law and legal representative. Okay. Legal rules of a minor. Sorry. Rules governing minors agreement. Rule 1 and Rule 2. Rule 1 is judges are consular means jury is the equivalent on law is the graduation. Means Rule 2 is a case minor means any minor entered into the contract means unlawed means legal immoral means immoral as a procedurable and under the relevant laws. Okay. Legal laws for minor. Person in agreement with the minor is valid intended into is not liable to return the benefits it's received under valid agreement. His minor can be beneficiary and minor cannot be his agreement on attending in the age of the majority. Means he can enter into the contract for his necessary and minor can be the shareholder and minor cannot be the partner and minor can as the agent. This minor is liable to punishment of criminal offenses. This is the unsound person according to section 12. The person generally sound means essentially unsound can enter into the contract when he of sound mind means a person generally unsound or socially sound can enter into the contract and when it is a sound mind means person for unsound mind means logistic idiotic and means intoxic persons means any unsound persons is the person is said to be an sound mind for the purpose of making a contract means if at a time when the makes he is capable of understanding forming rational judgment and to effect upon his interest rate Okay. Love tick means all suffer to from intermediate condition of scientific instinct, ideologically, drugless, pre-constant, हे काही एवढं हे नाहीये, pre-constant corrosion, पीपीटी खूप आहेत त्यामध्ये जे जे मेन आहे त्याच आपण बघतोय. हा, फर्स्ट मिस्टेक एक पॉइंट आहे. मिस्टेक when mistake can define the incorrect idea or opinion about something, means type of mistake of law, means Indian law, ignorance of law is no excuse, means foreign law valid, means mistake of fact, means bilateral, means bilateral mistake and unilateral mistake. It is bilateral mistake according to section 20, means where both the parties to agreement are under the mistake as matter of fact, means essential to agreement the agreement is valid. Means by mistake, bilateral mistakes is to subject matter. First is the mistake has to vary existence of the subject matter. Second, mistake has to identify the subject matter. Third is mistake to quality of the subject matter. Fourth, mistake has to quantity of the subject matter. And fifth, mistake has per title of the subject matter. Means then mistake has to price of the subject matter. This is main bilateral mistakes. Bilateral mistake is the possibility of performance to contract, means physical impossibility and legal impossibility. Then second type, unilateral mistake, means one of the parties to the contract is the under mistake as the matter. Means of fact is known as a unilateral mistake. Is the contract is not valuable because it was caused by one of the parties to its beginning under a mistake. Okay. हे इंडियन लॉज मधले आहेत. मला वाटत असेल काय चाललंय. इंडियन कॉन्ट्रॅक्ट लॉ 1872 असं टाका. पूर्ण त्याचे असं एक बुक आहे. बुक पेक्षा त्याचे पीडीएफ डाउनलोड केले तर पण कुठल्याही सेक्शनला कुठले लॉ ऍक्ट होतात, अग्रीमेंट कुठले आहेत, कॉन्ट्रॅक्ट कुठले आहेत ते आपण तुम्ही बघू शकताय. ओके. त्याचे काय वर्ड कॉन्ट्रॅक्ट कॉन्फिडन्स पण नाही. परफॉर्मन्स आहे. हा, परफॉर्मन्स ऑफ कॉन्ट्रॅक्ट. Actual performance, attempt performance. There are two types. Actual performance of contract is the एकच मिनिट. Performance of contract means actual performance and attempt perform. Actual perform means when both parties perform, means their promises and there is nothing remaining to perform. And then second, attempt perform means when the promisers offer to the perform, means his obligations but promises refuses, means accept the performance. It is also known as a tender. Means when performance of contract is the terms, means that the both promisers, means the promiser and promises has a fulfill their respective obligations, means which the means which the contract placed upon them. Means for instance, A visited and stationary, means B the main example of the performance contract. Means the contract relevance to the person from further duties under the contract. Means the main actual and attempt performance is the condition of performance. Unconditional performance, conditional performance is the unconditional, proper time, proper place, opportunity to examine and for the whole obligations. Main duties means unconditional, it is made as per the terms of contract. Proper time means it is performed within the stipulated time, means or during business hour. Proper places means stipulated place or promised place of the business. Main person who must perform the contract means promise himself. Promiser filters means person authored by the promiser, legal representative, third person, and joint promisers. The first delegation of joint liabilities. These are the main delegation means transfer or passing over from one person to the another. Means according to section 42, when the joint promisers means by the legal representative means must fulfill the promises and jointly when the surveying the promises according to 43 means section 43 means when two or more person make joint promises means may the absence of express agreement to the contrary means comply any one or more of such joint promises to the perform the whole of promises. Okay. Then last point assignment contract नहीं है तो point specific performance supply section guarantee section 122. Okay. Contracts of guarantee is the contract means perform the promises of discharge and the liability of third person in the case of his and the person means any use guarantee is known as a security means the person respect of the whom the guarantee is the given known in principle the person to whom guarantee is the given creditor for the either oral or written. Okay. Then essential features of guarantee means concerns of three contracts means primary liability is that of principal debitor. In case of debitor is the security liability because the primary. All the essential of valid contracts it may be written and oral and there is need not full disclosure of facts and surety gives the guarantee. Okay, main Indian contract 1872 the main contracts law. Okay, खूप पीपीटी त्यामधले जे जे पॉइंट आहेत तेवढंच मी ते तुम्हाला सेंड करेन. आता आपण स्टॉप करूया. ह्यामध्ये मेन कॉन्ट्रॅक्ट लॉ मध्ये डिटेल मध्ये आहे. सो जसं जसं तुम्हाला सेक्शन्स कळतील त्यामध्ये काय आहे ऍक्सेप्टन्स कॉन्ट्रॅक्ट लेटर त्याचे लॉ काय आहे सेक्शन कुठले आहे तेवढं समजलं तर पण बरं आहे. ओके, दुपारच्या लेक्चरला हे करूया आपण. ह्या 2-3 दिवसात थर्ड युनिट झालं की नेक्स्ट वीक मध्ये तुमची रिआयसी प्रेझेंटेशन आहे त्या तयारीला लागा सगळेजण. ओके, पण स्टॉप करूया 12 वाजलेले आहेत. रोल नंबर चॅट बॉक्स मध्ये टाका. थँक्यू. स्टॉप करूया आपण.